Here's an example of an evidential flowchart that the police use now, and there's some information on key facts for police officers. So I'm just going to end by saying that in order to move towards this fair and rational legal and policy response to HIV in the criminal law, what we need are legal decisions based on good science. We need law enforcement guidelines for police and for prosecutors. We need good access to justice, and that means helping people living with HIV understand the law and their duties under the law, and access to good defense lawyers so that people aren't just pleading guilty without realizing that they actually may well have a good defense. And really, over the years, I mean, since the Curry decision, those 12 years, so much has happened in terms of what we know about HIV, in terms of life expectancy, how HIV is transmitted, and the impact of treatment on transmission. So we need to incorporate and improve knowledge of science. We also need dedicated and influential individuals on both sides to actually have a dialogue. And you also need broad stakeholder collaboration, so that means the community, the police, the judges, and the media all need to come together. So I hope that's something that's already starting to be achieved in Canada, and I really hope that tonight, with this launch, you can move forward and achieve a fair and rational response. Thank you.
Thank you, Edwin, and thanks for being here with us and sharing your expertise. Edwin's blog, if you haven't seen it, is truly an incredible resource for all of us that are fighting to try to limit the application of the criminal law, to prevent the criminal law from being applied in cases where it's not warranted. Edwin has given you the global context and has introduced you to a little bit of where Canada sits in that context, and it's my job to tell you a little bit more of the detail about where things stand in Canada. And I think in doing so, it will become abundantly clear, or at least I hope it will, as to why we actually need to take the steps that we're talking about here tonight to bring some clarity and some rationality and some consistency to the application of the criminal law here in Canada. We can, I think, roughly divide the history of using criminal law in Canada to deal with HIV into two phases. The first is a pre-1998 phase. The second is a post-1998 phase. What happened in 1998, of course, as you've heard mentioned already, was the judgment from the Supreme Court of Canada in the Courier case. Up until that time, there had been a handful of cases in, every year since the beginning of the epidemic, up until this decision by the Supreme Court of Canada. And in some years, there in fact had not been any prosecutions that had been brought forward. That was partly because there was an uncertainty in the minds of police and prosecutors as to which offenses in our criminal code they could apply to situations where someone had either transmitted HIV without their partner knowing their status, or had put someone at risk of infection without their partner being aware. And so there were any number of different prosecutions brought forward under different sections of the criminal code, but we were talking about a relatively small number, obviously troubling for those involved, but not necessarily indicative of a wave of criminalization. Once the Supreme Court of Canada was actually called upon to address this issue and decided that in fact one particular section of the criminal code could be used fairly straightforwardly to deal with the question of people not disclosing their HIV status to sexual partners, we then saw, with the legal pathway having been clarified, a significant increase in the number of prosecutions. And every year since then, we've seen an increase in prosecutions, with one or two exceptions. But if you look at the data, you'll see a fairly clear division between pre-1998 and post-1998. The key thing that the Supreme Court decided in that case was that the offense of aggravated assault, or by extension the similar offense of aggravated sexual assault, could be used to convict someone for not disclosing his or her HIV-positive status to a sexual partner. But one of the things that the court was very clear to say, partly because of the interventions by a number of organizations who urged them to be careful about using the criminal law, was that there is not a general obligation to disclose in every circumstance. There is an obligation to disclose before doing anything that poses a significant risk of transmission. That was the test, that was the threshold that the Supreme Court of Canada adopted. And they did so perhaps understandably because the criminal law is usually concerned about dealing with harm or risks of harm from one person to another. That's the primary function of the criminal law. And so, having accepted that there was not always a duty to disclose, they decided that there had to be a significant enough risk of harm before the criminal law would be triggered. The question, of course, is, well, what does that mean, a significant risk? And that is where all of the confusion has since followed in the courts in Canada. It's very clear, we thought, from the decision by the Supreme Court, that if someone is HIV positive and has unprotected anal or vaginal sex with a partner without disclosing, that those acts would be considered to pose a significant risk of transmission, and therefore there was a legal duty triggered to disclose in those cases. At least where the person who is positive is the penetrative partner. More recently, just earlier this year, we have seen a judgment out of Vancouver, a trial court decision, in which the HIV positive accused man was actually the receptive partner in some acts of unprotected anal sex, and based on the medical evidence that was before the trial judge, she actually decided that there was not a significant risk of him transmitting to his partner in that case. So there we have some uncertainty already being introduced into the law, even when it comes to something that we thought was actually fairly clearly established by the Supreme Court of Canada. It remains to be seen what other courts are going to do in future, depending on the medical evidence that's put before them. But what about sex with a condom? This was actually a key issue that was raised before the Supreme Court of Canada. And the thing that we got out of that judgment, notwithstanding the fact that many of the concerns we raised were dismissed fairly summarily, I'm afraid, by the majority, at least we got a recognition, and this is a small victory, but you take what you can get, that the careful use of a condom might lower the risk enough that it would be no longer necessary to disclose because there would no longer be a significant risk of transmission. That's something. It's not everything we would have wanted, but nonetheless it was a recognition that the criminal law needed to be limited in some way. Two of the judges on the Supreme Court actually would have gone further because they said it's not good enough to just say if there's a significant risk you have a duty to disclose, because that's too vague. And that's going to lead to injustice in its application. And in fact, I think that's been proven to be the case. Partly because of that concern, those two judges who were in a minority said very clearly that the law should not apply to cases of protected sex. That if you use a condom, there would be no duty to disclose, and the criminal law of assault would not step in. That was a minority judgment, and the majority only said maybe that's the case. In a number of cases that followed, at least 6 of which I'm aware, and there may have been others, it seemed that the courts were accepting this suggestion by the Supreme Court, the so-called condom defense, if you will, or the exclusion of sex with condoms from the ambit of the criminal law. None of them were dealing with it at any particular length or clearly expounding on that, but it was fairly clear from most of the judgments that they were content to limit the criminal law to just cases of unprotected sex. However, this too has now been thrown into question because we received last year a judgment from a court in Winnipeg in which the court very specifically says at some length, a condom alone will not suffice to reduce the risk. So even if you used a condom, you must disclose, and if you don't, then you could be convicted of aggravated sexual assault. That decision was appealed, quite rightly, and we intervened before the Manitoba Court of Appeal to argue that the judge got it wrong and that in fact a condom should suffice to protect people against criminal prosecution. We argued that case in February and we're still waiting for a decision.